All right, well, thank you very much, David, for that introduction. It's great to be back at my alma mater. I have many fond memories of my time here, and I'm very happy that some of the people that taught me while I was here, Professor Ziff and Professor Bauman, have come along today, and of course the Dean, Phil Bryden. I'm glad that he's been able to come along, and my friend Barb Billingsley is here as well, so I'm really delighted to be back here. As I say, I have a lot of fond memories of my 3 years here back in the late 80s and early 90s. And it's good to, and I was delighted to be invited to deliver this lecture, so I'm grateful to you, David, and to the Dean, Phil Bryden, for extending that invitation to me. So I'd like to start with a story, and it's something that happened to me earlier this year. I was on vacation with my family in Honolulu, Hawaii, and on the 28th of June this year, as we were strolling along Kalakaua Avenue on Waikiki Beach, I noticed something that would certainly seem quite out of place on any major Australian street. A person carrying a sign announcing simply that Jesus saves your lives had found herself inches from another person wearing sandwich board signs inviting people to fire semi-automatic rifles and handguns at a local gun range, which it turns out was in a shopping mall just off Waikiki Beach. And for me, the juxtaposition could not have been starker. The two issues that seem most to typify the United States to the rest of the world, and which also seem to fascinate the rest of us, religion and guns, squared off as represented by two adherents to those positions. It captured perfectly Barack Obama's now famous 2008 declaration about small-town America, that they cling to guns or religion. Yet it was anticlimax. Here on the street of this American city, the proponents of what might seem to us in Australia as two very different ways of looking at the world, and which Obama has forever linked together in the world's view of America, stood for a few moments mere steps apart, hardly giving the other a second glance, before moving off in different directions into the crowd, off into the night, to win new converts. And you may have noticed the date on which this occurred, the 28th of June, 2013. Well, this little non-showdown on Kalakaua Avenue was taking place that I witnessed. American newspapers and media outlets that day were filled with news of a much more vitriolic, and for many in the United States, much direr showdown. The headlines were reporting the news of the U.S. Supreme Court decisions in the United States in Windsor and Hollingsworth and Perry, handed down the day before, and which had respectively invalidated the U.S. Federal Defense of Marriage Act, or DOMA, and in the second denied the right to appeal from the decision of the U.S. District Court in California, which had held unconstitutional Proposition 8, which had been enacted by ballot initiative in 2012 and placed a ban on same-sex marriage. Thus, the Supreme Court left intact the District Court ruling. The decisions were being hailed or vilified depending on the position one took on same-sex marriage. And those two cases had been closely followed and hotly debated, not only by Americans, but also by those following the issue of same-sex marriage the world over, including in Australia. The Supreme Court, in fact, will continue to be busy in dealing with religion, having agreed to hear in its next term, beginning in October this year, Elmbrook School District and Doe, which involves whether the First Amendment to the United States Constitution bars a state school from holding public functions in a church building for purely secular reasons, and Town of Greece and Galloway concerning the prayers with which a New York town board opens its meetings. So it struck me on the 28th of June, as it has often, just how much religion is at the very surface, not only of American life, but also of American law. On the 28th of June, religion was not only overtly evident on Kalakaua Avenue in Honolulu, but also in the courtroom in Washington, and I'm sure all across the country in some way or another. And that made me think of Australia and the place of religion both on the street and in the courtroom, where religion never rises to the surface of public life in quite the same way. In fact, the author of the magisterial 5-volume History of Australia, Manning C. Clark, probably captured best the Australian approach to religion, both for the individual in private life and for the polity in its public life, when he wrote of Australian religion over half a century ago that it is, and I quote, a shy hope in the heart, close quote. And more recently, Gary Bauma, a prominent Australian sociologist who in 2004 wrote the groundbreaking Australian Soul, which explored the place of religion in Australian society and elaborated upon the work of Manning Clark, sees the Australian approach to religion or spirituality on the one hand, and unlike America, as much less use of neon lights and much less explicit public spirituality, while on the other hand, unlike Europe, there is, Bauma writes, a comparatively high vitality of Australian religious and spiritual life. In fact, I'm just going to summarize 12 points that Bauma makes about spirituality and religion in Australia, and I know that a list of 12 sounds like a lot, but I've just narrowed it down to 12 simple points, which I hope will make overall the point that I'm trying to make about the place of religion in the life of Australia. And so he says, that is, Bauma says, that religion can be characterized by these 12 themes. First, that there is a serious but light touch in dealing with religion. Second, there is a wariness of enthusiasm in religion, and especially high demand religion. Third, there is a wariness of imported mass culture religion and spirituality. Fourth, a serious distancing from authoritarian leaders, promoting sacred causes or sacrifice for principle. Fifth, a serious commitment to living for now and not sacrificing for the future. Sixth, an antipathy to empty formality. Seventh, a serious, and this is an Australian phrase, a serious mateship grounded in shared experience. Eighth, a serious tolerance of difference flowing from a commitment to seeking a fair go, again an Australian phrase, a fair go for everyone and keeping an even keel. Ninth, a serious readiness for humor and to laugh at oneself. 10th, a serious quiet reverence, a deliberate silence, including comfort with an inarticulate awe, and a serious distaste for glib wordiness. 11, a serious wariness and intolerance of, in inverted commas, gatekeepers, the straighteners, and God's police. And finally, 12th, the preference to live and let live, tolerance grounded in mutual respect, as opposed to enforcing one group's viewpoint on others, as a primary mode of acceptable interreligious group relations. So in other words, Bauma's analysis demonstrates that for Australians, qualitatively, while it may be understated and wary of excessive public displays, religion and spirituality is very much part of life at the personal level of the individual, rather than that of any structured, organized religion. Indeed, for individuals, there may be a rejection of religious organizations, such as churches or temples, in favor of a blended form of spirituality, drawing on a number of otherwise unrelated religious traditions. And quantitatively, the most recent census data and Bauma's own empirical analyses support the conclusion that religion or spirituality is certainly present in the lives of Australians. In short then, while it is there, Manning Clark's shy hope in the heart still seems to characterize the Australian attitude towards religion, and it captures perfectly what I want to talk about today. Rarely does a scene like the one that I saw that night in Honolulu occur in an Australian street, subject to something I'm going to talk about in a few minutes. When it does, when something like what happened on Kalakaua Avenue happens in Australia, as we'll see shortly, it certainly does not go unnoticed, as it did that night on Kalakaua Avenue. There was really no reaction to these overt gestures in relation to religion. But what is more, and what I want to talk about today, is the fact that the attitude of Australians toward religion seems also to characterize the approach of Australian law to religion. For Australian law, both historically and today, treats religion as though it was a shy hope in the heart. So to understand what I'm getting at, we need to look back over the course of Australia's constitutional history to the approach taken towards the protection of human rights generally and religious freedom specifically. And when one looks at this, one finds that rather than anything like the comprehensive explicit approach to human rights found in many other Western democratic states, including Canada, Australia has protected human rights through a minimal, piecemeal, patchwork approach of constitutional, legislative, and common law provisions, differing not only in their applications to the Commonwealth and the state and territory governments in the Australian Federation, but also in the scope and strength of the protection afforded. And given the complexity of this piecemeal approach, I want first today to provide an overview of the limited protections found in the Australian Constitution. Second, I'll look at the protection that religion might find within the context of the implied constitutional right of political communication. And finally, given the constitutional gap that you will see emerges from the analysis of those two aspects, I want to look at efforts by state and territory legislatures to fill the gap, the constitutional gap, through exemptions to equality found in legislative anti-discrimination regimes and human rights charters. And in relation to each one of those three areas of possible protection, I'll also consider a recent judicial approach to religious freedom in the Australian courts. First, in the case of the Constitution's express protection of religious freedom, I'll look at Williams and Commonwealth, or the case that has come to be known as the school chaplains case, which was decided by the High Court of Australia in 2012. Secondly, in the case of the implied right of political communication, I'll look at the Attorney General and Corporation of the City of Adelaide, or what's come to be known as the street preachers case, which was decided by the High Court earlier this year. And finally, in relation to the exemptions from anti-discrimination legislation, I'll look at a case by the name of OV and members of the Board of Wesley Mission Council, which was decided by the New South Wales Court of Appeal in 2010. Together, my point will be that these cases merely replicate a long historical approach toward religion in Australia, constitutionally, legislatively, and judicially, which reveal in turn an attitude which deals with religion, yes, but without ever explicitly saying so, or comprehensively saying so. In short, for Australian law, as for Australians themselves, religion remains a shy hope in the heart. So to turn first to the Australian Constitution, the Constitution itself empowered the federal Australian Parliament, or the Commonwealth government, to make laws with respect to external affairs. And it enabled it to, that is, the Commonwealth government, to implement by way of legislation international treaties and covenants, including those that contain human rights norms. Still, notwithstanding the fact that that power was placed in the Australian Constitution, the framers ultimately included no Bill of Rights to deal with human rights in a comprehensive fashion. Instead, they opted to provide the barest protection of human rights, with religion finding protection only in Section 116 of the Constitution, which seems, on its face, expressly to deal with religious freedom. And it contains 4 parts or 4 limbs, and I'll just quote a section for you. The Commonwealth shall not make any law for establishing any religion, or for imposing any religious observance, or for prohibiting the free exercise of any religion, and no religious test shall be required as a qualification for any office or public trust under the Commonwealth. And this provision found its way into the Constitution as a result of petitions which had been circulated at the time of the constitutional conventions in Australia, which were held pre-Federation, so in the late 1890s. And those petitions demanded that the Constitution include reference to the Christian identity of the new nation. And so difficult though drafting that reference was, the framers ultimately settled on including something in the preamble to the Constitution, which read as follows: whereas the people of New South Wales, Victoria, South Australia, Queensland, and Tasmania, the founding states of Australia, humbly relying on the blessing of Almighty God. That's the preamble, and then it goes on to establish the Constitution. The mention of Almighty God then reopened a debate that had also been occurring at the conventions about prohibiting religious tests and religious establishment on the one hand, and a concern to limit restrictions on the free exercise of religion on the other. And ultimately that resolved itself in the compromise of Section 116. So the concern that some mention of Almighty God was made in the preamble was then a concern to some of the framers or the drafters of the Constitution that clearly was then granting power to the Commonwealth to deal with matters of religion. and therefore there would need to be some limitation upon that power elsewhere in the Constitution, and that leads to the inclusion of Section 116. And that seemed for the framers to strike a balance between those two sets of opposing fears. Yet, because it operates as a constraint only upon the federal legislature, Section 116 prohibits the Commonwealth, not the states, from legislating to establish a religion or to limit the free exercise of religion. And while the Australian provision goes further than the First Amendment to the US Constitution, prohibiting not only federal laws establishing any religion, but also the use of religion to impose religious observance or to administer a religious test as a qualification for public office, the potential that seemed or seemingly was contained in the text, unlike its American counterpart, remains largely unrealized. Responsibility for the limited use of Section 116 lies squarely with the Australian judiciary, the courts. While the American judiciary invokes the First Amendment to protect the right to freedom of religion, Australian judges historically treat Section 116, notwithstanding its remarkably similar wording, as part of a 19th century British statute, rendering it a virtual dead letter as a means of conferring any substantive rights, and rendering it of little practical import as a tool for protection of religious freedom in Australia. Paradoxically, that narrow interpretation flows from the judicial assertion that Section 116 is dislocated from a Bill of Rights properly understood. So notwithstanding the fact that the framers decided not to include a Bill of Rights, the judiciary has used that fact as a reason why Section 116 and the other minimal human rights protections found in the Constitution should not be broadly interpreted. In fact, in what is celebrated in Australia, the case known as the Dogs case, the defense of government schools, the acronym is DOGS, so it's known as the Dogs case. In that case, the High Court noted that Section 116 does not represent a personal guarantee of religious freedom, but rather a denial of legislative power to the Commonwealth and no more. And that approach has led the High Court on numerous occasions to reject claims that legislation infringes upon the freedom of religion. Failed claims have included the following: Krieger and Williams, that compulsory peacetime military training offended the religious convictions of persons who believe that military service is opposed to the will of God. In Kruger and Commonwealth, that the use of legislation for compulsory removal of Aboriginal children from their families prohibited them from access to and free exercise of their spiritual and religious tradition. And in the Attorney General of Victoria and Commonwealth, that government funding of religious-based schools amounted to an establishment of religion. The High Court's recent effort to deal with Section 116 has added nothing new, other than to confirm the reluctance of the court to develop its ambit. And that takes me to the Williams and Commonwealth decision of the High Court, which, as I said earlier, was handed down in 2012. That case involved a constitutional challenge to the Commonwealth Government's National School Chaplaincy Program, or the NSCP. The plaintiff, Mr. Williams, was a father of 4 children, and those children attended the Darling Heights State School in the state of Queensland. The school participated in the NSCP under the guidelines of which the school chaplains would, among other things, and I quote, provide general religious and personal advice to those seeking it, and would work in a wider spiritual context to support students and staff of all religious affiliations, and not seek to impose any religious beliefs or persuade an individual toward a particular set of religious beliefs, close quote. The Queensland Scripture Union, a Christian group, was engaged or contracted by the state of Queensland to deliver those chaplaincy services. And the funding pursuant to which the Scripture Union was contracted to provide those chaplaincy service had no statutory basis. Rather, the NSCP was administered by the Commonwealth Government purely by way of a series of funding agreements out of the Consolidated Revenue Fund. And Mr. Williams argued 2 distinct constitutional grounds. First, on the 4th limb of Section 116 of the Constitution, which, as I said a moment ago, provides that no religious test shall be required as a qualification for any office under the Commonwealth. And Mr. Williams argued that the definition of school chaplain in the NSCP guidelines which required that the person be recognized through formal ordination, commissioning, recognized qualifications, or endorsement by a recognized or accepted religious institution, Mr. Williams argued that that imposed a religious test for that particular Commonwealth office, contrary to the Constitution. And Mr. Williams failed at the threshold in that argument. The High Court found simply that the chaplains engaged by the Scripture Union held no office under the Commonwealth, and that the funding to the Scripture Union by way of the NSCP was insufficient, this is quoting the High Court, to render a chaplain engaged by the Scripture Union the holder of an office under the Commonwealth. There needed to be, the High Court held, a closer connection to the Commonwealth in order for the religious test under Section 116 of the Constitution to be enlivened. Justice Hayden in the High Court additionally appeared to doubt whether the NSCP even imposed a religious test, because the work provided by the school chaplains could have been done not only by persons who met a religious test, but also by persons who did not. And so the court went no further in defining what a Commonwealth office might be for the purposes of Section 116, or how the nexus between a religious test and a Commonwealth office might be established pursuant to 116. Instead, while that argument was unsuccessful, the High Court did find for Mr. Williams on the second ground or argument that he made, and that was based on Section 61 of the Australian Constitution, which vests executive power in the Commonwealth Government that extends to the execution and maintenance of the Constitution and of the laws of the Commonwealth. And Mr. Williams argued that that did not empower the Commonwealth to enter into the NSCP funding agreements absent an explicit statutory basis. And the High Court held that the executive power found in Section 61 did not authorize, therefore, that funding. The result of the case, rather than being confined to examining what might constitute a religious test for a Commonwealth office under Section 116, rather than being confined to that, had the result of invalidating a vast number of Commonwealth funding programs for want of statutory authorization for their expenditures. And in fact, the Commonwealth government responded by rushing through emergency legislation purporting to validate all such expenditures by the Commonwealth government, and also allowed the NSCP to continue in a slightly altered form as the National School Chaplaincy and Student Welfare Program, or the NSC-SWP. Australians love to abbreviate everything, so they refer to it now as the NSC-SWP. The result has caused considerable controversy, and Mr. Williams, who had hoped for a result on religious grounds, has already indicated that he will again seek to challenge the constitutionality of the new NSC-SWP on religious grounds again in the High Court. And it remains to be seen then what will become of that new program, the slightly altered program. But in any event, Williams and Commonwealth demonstrates the narrowness with which Section 116 protection is interpreted, or the reticence of the courts to rely upon Section 116. And so, although it may appear as though Section 116 had what might be seen as an expansive approach to religious freedom, in its judicial interpretation, Section 116 has failed to provide what some might hope for as a robust protection of religious freedom, similar to its U.S. counterpart under the First Amendment. So given that that seems to result in ambiguous protection for religious freedom, the second area that we might look at is a right that has been more recently found in the Australian Constitution, the right to freedom of political communication, an implied right. Unlike the U.S. First Amendment guarantee of free speech and free press, the Australian Constitution contains no such protection in relation to freedom of speech or the press. And it was perhaps this absence that led the High Court from around the late 1970s to find a further set of implied guarantees in the text and structure of the Australian Constitution. So beginning in about 1975, Justice Lionel Murphy, who was the great dissenter of his day in the High Court, and I suppose in terms of implications into the Constitution, something like the Australian equivalent to Ivan Rand in Canada in the 1950s, He began to foreshadow the possible existence of a number of implied rights, and I quote, "so elementary that it was not necessary to mention them in the Constitution." And those propositions included a freedom of interstate travel, a prohibition on laws permitting slavery or serfdom, a prohibition on cruel and unusual punishment, and a limit on legislation authorizing arbitrary discrimination between the sexes. This became known as Justice Murphy's Constellation of Rights, and at the time that he started to propound it, it was roundly criticized. As I say, he was the great dissenter. He was always in 6-to-1 decisions against him on these sorts of implied rights arguments. He was roundly criticized and ridiculed, frankly. But interestingly, after his death in 1992, an implied freedom of political communication was confirmed by the High Court in 2 decisions to be part of Australian law. The first of those cases, Nationwide News and Wills, involved a federal provision which criminalized the bringing into disrepute of a member of the Industrial Relations Commission. And the second case, the Australian Capital Territory and Commonwealth decision, concerned a federal attempt to prohibit political advertising on radio and television during election periods. And in both cases, the court struck down the relevant Commonwealth legislation as violating this implied freedom of political communication. According to Justices Dean and Toohey in Nationwide, the limit stemmed from the principle of representative government and could be implied even from a scant textual basis, the High Court held. The provision in sections 7 and 24 of the Constitution that members of Parliament be directly chosen by the people. And freedom of political expression, the High Court held, was a necessary precondition for representative and responsible government. The protection extends to communications between representatives and the electorate, as well as communications between all groups in the community, and applies even outside of election periods. Political communication, in inverted commas, is also a broad category encompassing all matters that may be relevant to debate in the Commonwealth Parliament or its workings. And subsequent cases have extended the freedom to non-verbal statements. For instance, one example of that is protests against duck hunting, which involve the retrieval and display of the bodies of dead and dying birds. Importantly, the freedom has also been said to be logically indivisible. So whereas Section 116 applies only to limit the Commonwealth government, it has been held by the High Court of Australia that the implied right to political communication would apply to matters both of Commonwealth and of state or territory concern. So as a restriction on legislative power, the implied freedom of political communication could certainly act to protect certain forms of religious speech. However, it is important to note that the freedom is subject to a proviso, similar to what you find in Section 1 of the Canadian Charter of Rights and Freedoms. And that proviso is found in the second limb of a test which was outlined by the High Court in a case by the name of Lang and Australian Broadcasting Corporation. So Lang first confirmed the existence of the implied freedom of political communication and held that laws which burden that political communication will nonetheless be valid if the law is reasonably appropriate and adapted to a legitimate end compatible with the maintenance of representative and responsible government. Thus, in the Rabelais case in the High Court, the Commonwealth Office of Film and Literature Classification was held to be compatible with the freedom of political communication, even if the refusal of the classification of an instructional guide to shoplifting effectively burdened political communication. Any political communication is likely to fall within the ambit of the constitutional freedom, but can nevertheless be subject to this reasonable restriction in the pursuit of some other goal. And that very issue, the issue of whether religious speech falls within the broader ambit of political communication, arose in the Attorney General of South Australia Incorporation of the City of Adelaide, or the Street Preachers case, which was decided earlier this year by the High Court. And that case involved 2 brothers, Caleb and Samuel Corneloup, and they were members of a South Australian religious association known as Street Church. And Street Church used amplifiers and elevated stages to preach against homosexuality, promiscuity, and abortion, and they did that in Adelaide's main pedestrian mall in the center of the city, Rundle Mall. And as you know, I work and live in Adelaide now, and the university is just a block away from this, so I, in fact, witnessed the Corneloup brothers on a number of occasions in Rundle Mall preaching these things as members of street church. It represents the sole example that I've witnessed since I've lived in Australia of anything like what I saw in Kalakaua Avenue that night on the 28th of June. Those sorts of things just simply don't seem to occur often in the public forum in Australia. And it certainly, as we'll see in a minute, elicited a less benign reaction from the community. In fact, in response to objections from local businesses along Rundle Mall, the Adelaide City Council enacted bylaw number 4, which provided that no person shall, without permission on any road, preach, canvass, harangue, give out, or distribute to any bystander or passerby any handbill, book, notice, or other printed matter. And, in fact, Samuel Corneloup was convicted of a violation of that bylaw in the South Australian Supreme Court. And as a result of that conviction, the Corneloup brothers sought a declaration of the bylaws invalidity. Now, as we already know, because Section 116 of the Constitution does not apply to the states, there was no avenue of appeal on that basis for the Corneloup brothers, so they turned to, and also there was no avenue of appeal for them under an exemption from anti-discrimination legislation, as you might find in some other Australian jurisdictions, because South Australia has not enacted that sort of legislative regime. So there was no avenue of appeal other than in relation to the implied freedom of political communication. So the argument that was made by the Corneloup brothers was, first, that the bylaw was, as it was enacted by the City Council, was inherently ultra-virus with respect to the various provisions of the enabling state legislation. So the bylaw-making power had not been complied with, so the argument ran, and so therefore was ultra-virus. And the High Court on that point, construed the bylaw power broadly and rejected that argument. The second argument, as I've said, was based on the implied constitutional freedom of political communication, as it had been outlined in the Lang case. And, as we know, that freedom is an implied right derived from the text and the structure of the Australian Constitution, and operates as a restriction on legislative and executive power both at the federal and at the state or territory levels. So, as I said, the High Court accepted that bylaw number 4 operated intra-virus in relation to the bylaw-making power, but held that it operated in a way so as to burden political communication, and also that the category of political communication was wide and could cover religious communication as well. However, having decided that, the High Court then turned to the second limb of the Lang test, which, as we know, provides a proviso that may allow for a burden if it meets legitimate objective, so that any laws which burden the political communication may nonetheless be valid if they're reasonably appropriate and adapted to a legitimate end compatible with the maintenance of representative responsible government. And the Court found that bylaw number 4, in fact, was an appropriate burden having regard to its stated purpose, namely that it was to prevent obstructions and promote convenience, comfort, and safety, and explicit exceptions for communications relating specifically to elections and referenda. So on those two bases, that it was for preventing obstructions and taking account of explicit exceptions for communications relating specifically to elections and referenda in the bylaw, they found that the burden was an appropriate and reasonable one. So the Court says that it strikes an appropriate or an adequate balance between the competing interests of political communication on the one hand and the reasonable use of roads by others on the other hand. In response to the result, the Corneloup brothers have indicated that despite their disappointment with the High Court's ruling on political communication, they nonetheless are satisfied with the finding that any refusal of permission from the Council must be grounded in the purpose of the legislation. In other words, the degree of the street church's obstructiveness rather than the content of their message. So they're happy that there's not been an interference with the content of their message. They're just simply being prohibited on the basis of the fact that they were causing an obstruction. So the Constitution then, either through 116 or through this implied right of political communication, provides some protection for religion, but in a somewhat obviously disjointed and piecemeal way. And I could tell you about recent attempts to establish a Bill of Rights in Australia, but that has a long history, and in every case it has failed, including the most recent attempt to do that, which was in 2008 to 2010, and it really is a story for another time. So I won't tell you about that aspect of the possibility for the protection of human rights, other than to say it has a long history of failure in the Australian context, including the most recent attempt at that. So the next and final part of what I want to talk about is then what possibilities are there for the protection of religious freedom in Australia through anti-discrimination legislation, and specifically exemptions for religious bodies in anti-discrimination legislation, or in the one state, one territory legislative Bill of Rights, or Bills of Rights, that are found in Australia. What protection can we find for religious freedom in those possible sources? Now, most Australian jurisdictions have in fact enacted legislation to prevent discrimination of various forms, including discrimination on the basis of religion and a lack of religious belief. But where no such prohibition exists, as in the Commonwealth and New South Wales jurisdictions, some religious groups have been held to fall within the definition of race, and therefore anti-race discrimination legislation has been held to apply, such as the the Commonwealth Racial Discrimination Act 1975. However, the prohibition of discrimination on the basis of religion is typically far from the primary purpose of such legislation, so not every one of those enactments contains some protection for religious freedom. Rather, those regimes normally afford protection that is for religion, by exempting religious organizations from particular requirements found in those general anti-discrimination enactments. So, if an exemption does exist, in order to engage in lawful discriminatory conduct, the party seeking to rely upon that exemption must establish that the discriminatory conduct conforms to the doctrines of that religion, is necessary to avoid injury to the religious susceptibilities of the adherents to that religion, or is based on the inherent requirements of a particular position of employment. The exemptions operate to the benefit of religious orders, bodies, or institutions more generally, as well as religious and non-religious educational institutions more specifically. Rather than offering a carte blanche to discriminate, exemptions generally are limited to particular grounds, differing as between jurisdictions. So where an exemption exists, there might be, for instance, permission to discriminate on the basis of sex, religious belief, marital status, sexual orientation, and so on. The granting of an exemption to a religious educational institution, for instance, might specifically permit discrimination in relation to student enrollments, or students' access to benefits or detriments, student expulsion, student dress and appearance, or, importantly, in relation to the employment of staff. There's a recent variant on that theme, which is, as I said a moment ago, the attempt by 2 Australian jurisdictions to enact legislatively comprehensive bills of rights or human rights protection legislation. So, as I say, there's 2 jurisdictions. One territory, the Australian Capital Territory, was the first to do this in 2004, and the state of Victoria followed suit in 2006. So in Australia you have the Australian Capital Territory, or abbreviated ACT. They enacted the Human Rights Act 2004, and then Victoria, as I say, followed suit and enacted the Charter of Human Rights and Responsibilities Act in 2006. Both of those pieces of legislation are essentially, in their structure and their operation, they're not identical, obviously, but they operate in the same way. So I'm going to just say a few words about the ACT example, but you can take that as being broadly representative of what happens in Victoria. So what some commentators refer to these two enactments as is Australia's first attempt at a Bill of Rights. Their legislation would be similar to the 1960 Canadian Bill of Rights Act. So the ACT Human Rights Act, or HRA, protects a range of human rights and freedoms. And in relation to religious freedom specifically, there's a Section 14 which enshrines the right to freedom of thought, conscience, religion, and belief. And Section 27 protects the rights of minorities to enjoy their own culture, religion, and language. And in addition to those specific religious rights, the HRA also covers the right to equality before the law, the right to life, the right to privacy, freedom of peaceful assembly, and so on, freedom of expression. And the legislation, however, preserves parliamentary sovereignty by leaving ultimate decisions concerning the violation of human rights to the legislature. And just to come back for a moment to that point I made a minute ago about the Bill of Rights issue in Australia being a long history of failure, that was the most recent attempt was in 2008 to 2010. And there was a commission of inquiry established to determine the protection of human rights, the current state of protection of human rights in Australia. And but the commission was expressly denied the possibility of reporting that a constitutional Bill of Rights should be enacted. So their terms of reference specifically excluded the possibility of a constitutional Bill of Rights and merely limited them to either modifying what already existed or at most establishing a legislative Bill of Rights. And the big debate that emerged was this concern about parliamentary sovereignty and the authority that might be given to the judiciary if a Bill of Rights is established, even by legislation. So that was something that was a major concern. And that grew out of these earlier legislative enactments in the ACT and in Victoria, where there was this concern expressed, and therefore the legislation itself expressly preserved parliamentary sovereignty by leaving it to the legislature. So this sort of a dialogue model, which became really sort of popular in the public debate about the Bill of Rights in 2008 to 2010, really then sort of resolved itself into another. There wouldn't really be much of a dialogue, but rather the legislature would have the sort of the final say on what human rights were and whether or not they'd been violated. However, there were a range of enforcement mechanisms within the HRA, or are a range of enforcement mechanisms, one of which is to vest jurisdiction in the ACT Supreme Court to issue non-invalidating declarations of incompatibility in cases where legislation cannot be interpreted so as to be consistent. So that idea of interpreting in a consistent way with the Bill of Rights is something that's common, I think, to legislative Bill of Rights, such as in New Zealand or the 1960 Canadian Bill of Rights Act. But this idea that there could be no invalidation whatsoever, rather you simply saying there's an incompatibility here and then leaving it to the legislature to decide whether or not it wanted to act upon that, was something, I think, somewhat new in the ACT form of this legislative Bill of Rights. There are two significant limitations in the ACT HRA. One is in Section 6, which provides that only, and I quote, only individuals have human rights. That's the first limitation. And second, and more significantly, that none of the enumerated rights in the HRA are absolute. So that's similar to the Section 1 of the Charter limitation. So in Section 28 sub 1 of the HRA, you have that section imposes a general qualification on each of the rights found in the Act. And I quote, the section reads as follows: human rights may be subject to reasonable limits set by territory laws that can be demonstrably justified in a free and democratic society. That language might sound somewhat familiar to this audience. And then a list of factors are contained in Section 28.2, which is intended to assist courts in determining acceptable limitation, or to assist generally in determining acceptable limitation, and includes the nature of the right affected, the nature and extent of the limitation, the importance of the limitation's purpose, the relationship between the purpose and the limitation, and the availability of any less restrictive means of achieving that purpose. And despite fears of an increase in litigation following the enactment of the ACT HRA, the invocation of the Act by the courts has mostly taken the form of a cautious, often superficial consideration of enumerated rights, usually used to bolster decisions reached on other grounds. In fact, only 2 cases have referred at all to Section 14, the protection of religious freedom of religion and belief, and in those 2 cases the mention was only brief of Section 14. So it really has not been used either broadly in relation to the protection of human rights in the way that some of its proponents might have hoped, and specifically in relation to religion it has not been used really at all. So then those are the 2 legislative approaches that the states and territories have taken to try and fill the constitutional gap in relation to the protection of religious freedom. So I just want to return for a moment in the last part of the lecture to talk about, to come back to that issue of the exemptions to equality in the anti-discrimination legislation in those states and territories that have such legislation. And in fact, quite amazingly really, the first appellate decision to deal with those exemptions was actually quite recently in the OV and members of the Board of Wesley Mission Council decision of the New South Wales Court of Appeal in 2010. Now, as I noted earlier, there has been a finding by the High Court that religious schools, that funding for religious schools from the Commonwealth does not violate Section 116 of the Constitution. And that wouldn't affect state funding for religious schools in any case. But nonetheless, there is a significant amount of both Commonwealth and state funding that goes to religious schools, non-state religious schools. And given the level of that financial support provided by both state and Commonwealth governments, religious schools have received criticism for their discriminatory employment practices so as to maintain their religious ethos on the basis that it subverts multi-faith and multicultural Australian ideals and undermines the promotion of equality through anti-discrimination laws. While religious institutions tend to accept non-religious students, the maintenance of the religious ethos through setting faith-based criteria for employment of teachers and other staff remains of importance to those groups that have established religious schools. The primary source for the ability of a religious school to discriminate in hiring practices therefore comes through the exemptions to the anti-discrimination legislation that I've discussed a moment ago. And so in OV and members of the Board of Wesley Mission Council, this case involved the Wesley Mission, a publicly funded body which refused to authorize OV and OW as foster carers on the grounds that their relationship was same-sex. And when the couple challenged the decision, alleging that it constituted discrimination on the basis of homosexuality and marital status, the Wesley Mission sought to rely on the religious bodies exemption contained within Section 56 of the Anti-Discrimination Act of New South Wales, enacted in 1977. And I'll just quote that, it provides that any other act or practice of a body established to propagate religion that conforms to the doctrines of that religion or is necessary to avoid injury to the religious susceptibilities of the adherents of that religion are exempted from the requirements of the legislation, the equality provisions of the legislation. The case, this case, OV and members of the Board of Wesley Mission Council, the Wesley Mission Council case, began in the Equal Opportunity Division of the New South Wales Administrative Decisions Tribunal, where the couple's complaint was upheld with respect to the homosexuality ground. Wesley Mission then appealed that to the appeal panel of the tribunal, with the New South Wales Attorney General intervening in support of their contentions. And the appeal panel set aside, so that is set aside the decision of the Administrative Decisions Tribunal, and that case, OV and OW, then appealed to the New South Wales Court of Appeal. And the Court of Appeal held that the exemption contained in Section 56 protected the Wesley Mission Council's decision to refuse the authorization of OV and OW to become foster carers due to their same-sex relationship. And in deciding the case, the court concluded that the correct construction of Section 56 requires decision makers to consider whether any allegedly discriminatory act conforms, at the time that it is made, with the particular religious doctrines that the relevant organization was established to propagate. And in response to that decision, a body known as the Christian Schools Australia, which describes itself as the peak body serving independent Christian schools in Australia, has suggested that the decision may have implications for allegedly discriminatory acts occurring in non-government schools across Australia. It asserted that schools seeking to rely on the Section 56 exemption or an analogous provision in another state or territory enactment would be required to demonstrate, first, that they seek to or were established to propagate a religion, and second, that the relevant religion contains particular doctrines relevant to the act in question. And the Christian Schools Australia body further suggests that standard statement of faith documents in school constitutions may be inadequate for such purposes, and forecasts the adoption of more expansive and codified doctrinal statements. So the New South Wales Court of Appeal's interpretation of Section 56 may therefore seem to operate as a double-edged sword. While it provides an extra avenue of argument for religious non-government schools being accused of discrimination, there is also the potential for insincere uses of the exemption in cases where discrimination has occurred and where legal recourse therefore ought rightly to be granted. So to conclude, that night in Honolulu for me, the 28th of June earlier this year, seems a world away from what we find in Australia. Not only do we rarely find such an overt display of religion on our streets, and when it does, it certainly does not go unnoticed, as we saw with the Cornluke brothers. We just as infrequently find it, that is religion, in our Constitution, our legislation, and our courts. So what we find is that it's not religion, it's political speech which is protected. It's not religion, it's an exemption from equality that is protected. And it's not religion, it's the way that it's funded that is protected. So Australian religion is, in law as in Australian social interaction, certainly Manning Clark's shy hope in the heart. Thank you very much.
Does anyone have any questions they'd like to address Dr. Babie?
It's my understanding that in the United States there's a growing trend towards secularism, where religious opinions are being discouraged and being put forward in the public square. Are you seeing any of that in Australia?
I think that probably, in a sense, actually sort of encapsulates, I think, everything that I've been talking about in the way that I mean, I don't know. I mean, I guess if we're going to say that religion is Manning Clark's shy hope in the heart, right? So on the one hand, I think that means that there isn't a lot of overt expression of religion, the Cornluke brothers notwithstanding. I don't think there is a lot of religious expression in the public forum in Australia in the same way that, I don't know, in the United States, rather than a shy hope in the heart, you might say that it's an overt expression on the sleeve or something like that in the United States. And I think that while there may be some attempts to restrict or limit that in the United States, I think it is certainly just something that is much more the fabric, part of the fabric of American cultural and social life than it is in Australia. So I guess the answer to the question is, I don't know that it's happening in Australia, but I don't know that there is much to be directed, if that was happening, that it wouldn't be directed towards much, because it simply isn't something that rises to the level of something that's being overtly expressed in the public forum. And I think that goes back to what Manning Clark was saying, where I started, and it goes back to what Gary Bauma, I should say, the sociologist, was saying about the nature of Australian religion and spirituality. It is something more personal to the individual, and that there's actually a reticence about expressing that in a public way.
I was looking more in terms of, say, policy debates in government level, lobbying and that sort of thing. Are the religious institutions in Australia then generally reticent to put forward their views to governments to try and get certain legislation enacted?
Yeah, I suppose that there is I mean, I guess the best answer I can give you to that question is to come back to that Bill of Rights debate. One of the things that I found sort of paradoxical about the Bill of Rights debate is that although there is always sort of a discussion in this public commission of inquiry about the fact that, well, religious freedom would be protected under any Bill of Rights. In fact, the religious groups were some of the most vocal opponents of any form of Bill of Rights, even if it did include a protection for religious freedom, because there was this idea that, look, we're happy, I mean, I don't want to sort of say too much along these lines, but the idea that we're sort of happy to fly below the radar the way that things are now, right, without a lot of notice being taken. We're happy with the exemptions to anti-discrimination legislation, so therefore we'd prefer not to have a Bill of Rights. It does that. So the answer then is, yeah, there was a lot of sort of there were a lot of submissions made by the religious groups at that time, but it was more about saying, look, we don't really want to get involved in this, so don't do this for us. And so I think that, yeah, there's not a lot of organization, but there seemed to, all of a sudden, there was a sort of a rallying of the troops at the point that you're talking about the Bill of Rights, but other than that, no.
Paul, given the religion's preference to fly below the radar,
Yeah.
the one jarring aspect of that tends to be in education, where the vast majority of private education
Yeah.
is done by very prestigious religiously based schools, and even within the state system. I was amused by your comment on the contracting out of the chaplaincy,
Yeah.
where religious instruction appears to be occasionally contracted out
Yeah.
to evangelical organizations.
Right, right. So, I mean, I think that there again, though, I think that the idea of the exemption to the anti-discrimination legislation, so that's, as far as religious organizations are concerned, that's operating just fine. We can do what we need to do based upon claiming that we have an exemption to whatever equality we might be otherwise required to adhere to by virtue of the anti-discrimination legislation, and that's sufficient. So yeah, I mean, I agree with you that religion is very much part of the educational system, but in a sense, the way that it gets there is through this sort of below-the-radar means, yeah.
Is there any debate in Australia about protecting polygamy or other kinds of marriage practices that would be acceptable in some religions but not in Judeo-Christian religious tradition or in mainstream Anglo-Canadian law?
Yeah. Certainly the issue of same-sex marriage has garnered a bit of, more than a bit, but I mean, it's not something, put it this way, it's not something that's on the front pages of newspapers. I mean, there's religious organizations that are making submissions both at the state and at the federal government, at the federal level, because both levels have been talking about how they might go about enacting some alteration to the federal law which governs marriage at the moment. And then the states have been talking about other means that they might do that doesn't involve the federal legislation. So there is there's certainly debate about that, but in terms of the broader issues in relation to such things as polygamy and so forth and other religious marital practices, no, I don't think that's become part of the debate. But the same-sex marriage issue is certainly something that is there, yeah.
Yeah, I mean, here it tends to be peculiar communities like Bountiful in British Columbia.
Right.
But there's a kind of underlying, well, if you get a larger and larger Islamic population
Right.
in the country,
Yeah.
where does that go in terms of people saying, well, our religion allows us to have multiple spouses?
Yeah.
Why is that different from same-sex marriage?
Yeah, and again, I mean, some, again, in the Islamic community, I mean, that, Islamic law is operating in Australia, but not at a level that is recognized by any level of government, right? So yes, that's there, and so it's almost sort of like, both sides are happy to turn a blind eye to this. The legislators don't want to get involved in dealing with that, and the communities themselves are happy to deal with it on the basis, in the Islamic case, on the basis of Islamic law, and leave it at that.
Richard?
Two-pronged question. First question is, Australia has an extraordinary rate of immigration, even greater than Canada's in terms of the foreign-born population in the country. How has that changed the religious composition of the country,
Yeah.
Australia? And secondly, does the government, when they conduct like a census in Australia, are they allowed to ask people's religious beliefs?
Yeah. So on the second answer, on the second question, yeah, they do, and that's how Gary Bauma has gathered a lot of his empirical data in relation to come to his conclusions about the nature of religion and spirituality in Australia. So yes, they do ask the question. So there's a whole range now. I forget what it is, what the minimum percentage is on the last census that you need to reach in order to get your religion then onto the list of religions. But yeah, there's 10 or 12 or 15 that are listed on the last census, which was what, 2010, 11 or something like that, 11. And then there's an other category that you can fill in. So that's there. How has immigration changed the religious makeup of Australia? Well, yeah, I mean, I think that's what Bauma is saying. So that things like Islam clearly is growing as a religion in Australia it's at a good rate, but it's still the overall percentage is still low. But in fact, one of the things that he found is that one of the fastest growing religions in Australia is no religion. Right, so people tick the box, no religion. But in fact, what he digs deeper into the data there, and he says, look, what people are actually saying is that they don't adhere to any organized, structured religion, but they do have this sort of like an amalgam of their spirituality is an amalgam of other religious traditions, but they wouldn't claim to adhere to any specific structured or organized religion. So although that no religion category is growing quickly, when you drill down into that, what you find is that people actually mean they have their own sort of form of spirituality or spiritual approach to life, which doesn't adhere to any of the named categories. Yeah. Okay.
In the case of the brothers, the two brothers, the preacher, I was just wondering what was it exactly that was stopped? You need both, but the way I look at that issue is perhaps it's either a question of form, how is it that they're expressing their ideas, or maybe it's a question of the ideas themselves. Because I mean, the ideas themselves, some people might find that offensive.
Right.
Do you know which one of the two or both? Which one was it that they can no longer do it?
So they can't really do. It's been found that the limitation on what it is that they're doing in the streets. So I mean, I don't think that the court actually got into the content of what it was that they were doing. They simply said that the bylaw was valid insofar as it required them to gain permission, and that the council could then refuse that permission on the basis of obstructiveness or whatever it happened to be. So the court, obviously clever in avoiding having to deal with that issue and not going into the content of what they were talking about. So it didn't get to that point. Yeah.
Much of Canadian jurisprudence has been devoted to trying to define religion, and the courts have basically defined it as an individual.
Right.
Your descriptions of exemptions and so on seems to me that the courts are taking the position that it's more a collective, right?
Right.
And this characterization?
No, I think that's right. Certainly in the case of the exemptions, although that there's another high court decision that deals with the purposes which defined religion in relation to for taxation purposes, for tax exempt status. And in that case, the high court says effectively you need to show that you adhere to some set of tenets or beliefs that are part of an organized religion. So that's I guess that's the classic definition. Although that applied to taxation purposes, so there's never been any definition of what it means in Section 116. And exemptions, yes, it's very much looking at it from the perspective of the organization of the body in question. So that's the way that's been approached. Justice Murphy would have taken the great dissenter again, he would have taken a much broader approach to the definition of religion, and basically the way that it's been summarized is if one's in, all are in. So anybody that would claim that they have some sort of religion, they just say, well, that's actually a religion, and then we'll go on and determine what the limitation or the exemption happens to be. So, but the law in Australia right now is narrower in terms of an individual that subscribes to a set of tenets or beliefs. That's the taxation definition, which a lot of commentators say, well, that's how it would probably go if they defined it under Section 116, but no court has done that. And exemptions is sort of taking the body's approach, yeah.
Okay, I think, Paul, people have to move on, so
okay.
I think I'll declare the formal part of this closed, and thank you very much indeed for coming and for taking the time to prepare such a substantial and interesting talk.
Thank you very much. Thank you for your time.